Welcome, fellow Biafrans, lovers of freedom across the world. I welcome you to this very platform once again. Thank you so much for being part of this platform. I appreciate everyone that is contributing in one way or the other to support this very platform. I thank you so much. We have come once again to preach the gospel of Biafra the way we have always done. Remember, in this very platform, we don't come here to instigate violence. We do not come here to preach hate. All we do here is preach the gospel of peace, the gospel of freedom, to bring the plight of the Biafran people before the whole world and to debunk every lie that the contraption called Nigeria have been telling against the Biafran people. That is what we are about to do now. Wonderful Biafrans, as you all know, the journey of freedom is still continuing in this era under the Biafra Republic government in exile on the command of our Prime Minister, Mazi Simon Ekpa. He is doing everything humanly possible to see that Biafra becomes free. Pay attention to this short clip. You will understand that all is not well. And the only way for you, as an indigenous person in that country called Nigeria, is to fight for your own freedom. If you're a Biafra, join the Biafra movement. If you're an Udua, join the Udua people. If you're from Arewa, fight for your Arewa. If you're from the Middle Belt, join the Middle Belt movement. That is the only solution. I want you to watch this clip from beginning to end. You'll be glad you did. Let's watch.
Mr. Dele, you are welcome to Inside Sources.
Thank you very much, Agbalaolu. It's a pleasure to be with you.
And, you know, Mr. Farotimi doesn't need a lot of introduction, but I was joking with him that you can actually introduce him as a retired lawyer, you know, I mean.
Oh, yeah. You'll be very correct to say that.
All right. So I want to start this conversation around the question of judicial reform and judicial ethics. Now, I think many Nigerians, especially people in the legal profession, and many of us who are also involved in public life, we have a clear understanding that there has to be quite a bit of reform generally in our society, but especially in the judiciary. So I want to start from your own perspective. You have practiced law certainly for more than 2 decades before you opted, I guess, to be a private citizen doing something else. What are the major reforms that you think ought to take place in our judiciary?
Well, we are as a people quite fond of doing what Yorubas would call amanfie tesile palapalapa. We ignore the leprosy and embark on ringworm curing exercises. It is not arguable that the Nigerian judiciary is in serious need, very urgent need of a turnaround. But when you look at it almost like it is only our judiciary, and by curing that problem, we would have resolved each and every one of our problems, it would be rather simplistic for anyone to make such pronouncements. But it is critical that the foundation of any state, which is the rule of law, must be strengthened by ensuring that fit and proper persons are the ones to be found in the judicial system. That would, of course, demand that the entire process of appointment and selection of judicial officers must be revisited. It cannot continue to be a place for prebendal expression of power and largesse. It cannot be a place where, because you are the CJ, your sons and daughter-in-laws, cousins, uncle, goats, qualified or not qualified, all of a sudden becomes qualified for judicial appointment. It cannot be a place that where you reward people who have been loyal to you, regardless of whether their loyalty is backed by patriotism to the country itself. It cannot just be a reward for the good old boys and girls who have served the system, which is what it has essentially been reduced to. And when you look at the end product, which should be the dispensation of justice, and you see that there is little or no justice available to anyone within the country, not even the rich and mighty and powerful any longer. Because what you now find are cacophonies of noises issuing forth from different courts, some type of coordinate jurisdiction saying different things. Look at the Kano situation, for instance. It says a lot about what has happened to us. When is a poor man who is in need of urgent judicial relief, you won't hear a thing. Nobody is offering anything. He might be there for the next 5 years without his case ever seeing the light of day. But look at how many injunctions fly all over the place. Once is the high and mighty, the powerful and the rich that are involved, even when it's their petty squabbles. But so when we're talking about judicial reform, we must understand clearly that the judiciary is but one out of the many aspects of our country that has more or less collapsed. It's only reflective of everything else. It's reflective of our educational system. It's reflective of everything about our country has come to the critical point where we must look at it honestly and stop lying to ourselves about giant of Africa and all the many lies that we tell ourselves to cover the truth of the destruction, wanton destruction of our country by those who have claimed to rule it. So, yes, we need urgent judicial reforms, but it goes beyond just looking at the judiciary. It's easier to despair when we look at our case, but yes, the judiciary needs urgent reform. It's not just about the human resource, even structural. There are urgent needs for serious structural reform in the judiciary. There is need to fund it properly. There is need to be deliberate about dispensing justice and not just appearing to be paying lip service to. How do you explain the way it is? Look at the number of people awaiting trials in our courts, and we claim to have a judicial system. It's a disgrace.
So I wanted to also, in breaking it down, I see two issues essentially, when we're talking about judicial reforms. Of course, we are looking at the rules, what the regulations are, the laws, as it were. Are there some of them that needed to change, And then there's also the issue of ethics, which is how those laws, those regulations, those rules are applied, misapplied, used, or abused. So I wanted to ask you, Bradley, in your own view, which is the more compelling problem of the judiciary? Is it about the rules that needs to change, the regulations, or the ethical question?
Look, Yorubas will say, "Onlamukun ẹ̀rù ẹ wọ́, olórí lẹ̀ ń wò ẹ wò sàlẹ̀." So you say to the crippled man with the load on his head, "Oh, your load is lopsided." And he responds, "You will call it lopsided because you're focused on the load on my head without looking at the crookedness of my feet." Let's be clear about something. There are sufficient rules in our books that should have stopped the retired Chief Justice of Nigeria from appointing members of his families as judicial officers. The Judicial Code of Conduct was sufficient, and you wouldn't ever have heard of any such thing before Nigeria began its speedy descent into the abyss of impunity. So when you hear me saying that corruption is not our problem in Nigeria, it is impunity, I will link it to the issue of whether it's about ethics or whether it's about a paucity of laws. We have enough laws in our books. We have enough rules in our books that should prevent the egregious abuses that we see on a daily basis that has debased our judicial system and rendered it completely unfit for purpose. There are more than enough laws and rules. So this is not about the paucity of written guidance on what should be done or not done by persons within the system. It is about a complete disregard for law. We don't even pretend that the laws matter any longer. Corruption is when the system says something should be done in a particular order or form, and then somebody is giving undue pecuniary benefit, and they then circumvent the system by speeding it up or doing something, maybe qualifying somebody who shouldn't qualify. That is corruption. But when you see a situation where people simply walk to the answer without caring anything for the process, that is what has happened to us. The same way they do wuru to the answer in answering university exam questions, promoting people within the system, it is the same thing they are doing in the judiciary. So even in judicial pronouncements now, you now see ever more ridiculous, obscene, and silly pronouncements issuing forth because there are simply no longer any regard have or had to common sense, what should be. Look, we have departed from the path of sense. That is why you have so many abominations flying up and down the place. It's about who has the power. Once they have the power, they don't care about consequence. They care nothing about it. So this is no longer, our case has moved beyond whether if we were talking about ethics, who is going to enforce the ethics? Who will enforce it? In the absence of a societal decision to walk away from this ruinous path that we all appear to have embraced as a collective. Because you would imagine that if the judiciary went mad like ours appear to have gone crazy, then maybe the religious orders, whether that be Muslim or Christian, would even have something to say to speak to the complete absence of justice, manifest and complete absence of justice from our system. But which one of them have you heard saying anything? Who has said a word? So it's not just about the judiciary, it's just that it is easier to point at the judiciary because if you heard the rumbling of thunder, you know it's easy for you to say rain is coming. So when what should be the last hope of the common man has become as hopeless as our own judiciary has obviously become, then it becomes alarming and we start talking about the judiciary. But which part of our lives as Nigerians really in truth encourages any hope? We all need to actually look at ourselves and tell ourselves the truth that what we have done to ourselves, our children, is not sustainable. We've destroyed this country, and if we don't call ourselves back, it will be beyond redemption very soon. How do you... I'm a lawyer. I was trained as one. I would even go as far as to sometimes argue that perhaps I was born one. But here is the thing. Even me, I have cases in the system. I went to court knowing I won't get justice. Just for the record, just so that people will not say, what did you do about it? That's how hopeless our judiciary has become. Only the rich can get any vestige of justice within the system. Only the rich. Only the rich and the powerful. The judicial system has become a tool for the oppression of the weak. People went out to protest hunger. I'm sorry, I need to make this point. People went out to protest against hunger. They went out to protest against hunger. You had somebody like Wike, governments all over the place, even the ones in Lagos State, they rushed all over the place, went to the court, to go and get injunction against people looking to protest. They used the judiciary to handcuff citizens, quote and unquote, who presume to demand the right to peaceful protest. The judiciary was the one, they used judges to issue pronouncements. To make the matter worse, the state went ahead and charged peaceful protesters for treason. Treason. You want to criminalize the right of protest? Treason. Hungry people came out, you are selling them daily, and you are criminalizing protest. And the judiciary has become complicit in the oppression and suppression of the Nigerian people. So if the people lose hope in the judiciary as they have, I have lost hope completely in the judiciary. That's the honest to God truth. If the people lose hope in the judiciary, what is left?
Clearly, there are quite a few people too who share those sentiments. You know, we have seen instances of very troubling decisions, and you know, and I'm sure that there are even deeper issues that most people don't know about. But before we get too deep into it, we had on this show Chief Kanu Agabi, two-time Attorney General of the Federation, and we were talking about, you know, the judiciary, and his argument was that, look, the judges have been overworked. And he said that whatever it is that we see happening in the judiciary is because the judges have been overworked. He gave an example and said that, look, there are judges who have to deal with as much as 20 or 30 cases in one day. You know, he even said that, look, he has worked in the executive as Attorney General, he has worked in the legislature as a senator, and being a lawyer, he has worked in the judiciary, that he still thinks that the judiciary is still the best. Now, the reason why I brought that one up is to say that certainly you too must think that there are still some good judges that are working in what you believe to be a bad system. I mean, how do you respond to that?
Let me put it this way. Every system is made up of persons. So every system is only as strong or as weak as the persons who make up the system. If you have 100 judges and you can only point at perhaps maybe 5, maybe 10, or even if you are generous, let's say 50 out of 100, and that is me being overly generous. Let's say 50 out of 100 can be said to be above board and capable of dispensing justice. And let's be clear, corruption is not only about collecting money to pervert justice within the system. Corruption is making up your mind about the case before you even heard the matter because of your own prejudices. So when you have a situation where a fair amount, even if it's 10 out of 100 that are corrupt within a judicial system, that's bad enough. But our judiciary is not any different from our police or our custom or our clergy or our teachers or our mechanics or our doctors for that matter. They are us. So when we start talking about our judges, and yeah, there are good ones amongst them, I've had occasion, I've been at the mercy of this same judiciary that I speak about all the time. I had a case where I was pursued through the court. I was convicted at the High Court. It took the mercies of the Court of Appeal justices who reviewed the appeal to quash my conviction. So it's not as if I'm speaking to a place where I am an angel and everybody are devils or demons. No. Is about the system that we have built. Even when good judges are within the system, the administrative judges will not give them cases that involves persons of power where they know that the judge would not do their bidding. These are things that lawyers know. There was once upon a time in this Lagos state when a particular person was in power as governor in Lagos state. When you sued Lagos State, and that is the practice until today, if you sue a Lagos State agency or you sue the Lagos State government, you will be collecting dates when the judges knew they would not even be sitting. So you might have a case in court for the next 5 years. Every time you went to court, you are going to get an adjournment because you are suing the parties that may not be sued. That's the kind of system that we have evolved. We've evolved. The best that our judicial system can deliver the way it is currently is maybe the administration of impunity. So you just take care of those that must not be touched, and at best give the semblance of justice to the victims of the system. But we've not evolved a judicial system that is truly capable of upholding the rule of law, dealing with everybody as equals, and truly being blind as the goddess of justice is meant to be, holding a just scale and a sword that would do justice as between the parties that are before it, until our country is structured to deliver justice, until the judges themselves are related to the people to whom they are meant to be dispensing justice, until each and every one of us understand the fact that the more we weaken the fabric of the society by making all these exceptions for persons that have rendered the system incapable of dispensing justice to all, our system is bound to grind to a halt one day the way we are going.
Quite sad. All right. I mean, so I have read a book that you, I think you must have written this book quite recently. Is the Nigeria and its criminal justice system. And you know what really struck me about the book was the case that you narrated, whereby there was a land matter in I think it's Lekki, Osapa area, where, according to your book, the matter got to the Supreme Court. I think it was a case that involved some of the families. I think there was a contest about, a particular portion of land, and the matter got to the Supreme Court. The Supreme Court made a ruling that gave judgment to the Eletu Badamosi family, 10 acres, if I got the number right. And then, as you reported in the book, that their lawyer went back to the Supreme Court and got the Supreme Court to increase the allocation of the hectares, after the Supreme Court itself had said, look, this family, all you get here is 10 acres. And then, so I mean, something happened, they weren't satisfied, went back, and the Supreme Court, in your book that you reported, gave the family almost or close to 250 acres. Now, Mr. Dede, can you just summarize to us what happened in that case for the benefit of our viewers, before we now try and, because I think this is something that we should look closely at. Can you give us a summary what happened in that case?
I thank God for the grace of life that I managed to write the book, that I'm alive to defend the truth, which requires no defense, that each and every one of the persons that I mentioned in the book are alive and well and able to deny what I have written concerning what transpired. But in order to answer your question, I'm giving this background so that I need people to understand very clearly that I'm not about persons. I don't really care much for persons. We're all bit part players. However high or low, we'll spend our time here and then we'll go. But we would all render account for whatever we do with our lives. So here is the thing. When I was much younger in practice, my first law office worked for the Ojomu family. They were more or less exclusively the lawyers for the Ojomu chieftaincy family. So I grew up in practice within that space, and I was fortunate to have, how when you are in a space, you hear different things. So I'd heard about the case involving the Ojomus and the Eletus since my very early years in practice. That case was at the time freshly decided at the High Court, and then it later moved on to the Court of Appeal, and it spent quite a while there, but eventually it came out, and the Court of Appeal still gave victory to the Ojomus. But I kept following these over the course of time, but because I live in the neighborhood as well as practice in that neighborhood as well. So I knew from way back that some people named the Eletu family and Badamosi Eletu had purchased land from the Ojomu family. And I knew that there had been that grievance about some fraudulence in relation to the deed. So by the time my clients were purchasing things in that neighborhood and they were asking questions about what kind of legal risks they might be running, I was careful to explain to them, because I have studied the case from very early in my practice, that, well, the totality of argument was restricted, obviously, to a very small part. So I gave legal advice based on my knowledge, not just of the law, but of the facts. So by the time the Supreme Court did delivered this judgment. I believe that must be in 2012, 2013. I can't really remember now. And the Eletu family started going around the whole of Osakpa, part of Ajiron, Agungi area, marking buildings, claiming that the Supreme Court had given them 254 hectares of land. I knew something fishy was going on. So immediately I asked a council in Abuja to procure the judgment of the Supreme Court as well as the enrolled order of the court. And we looked at it and we again advised our clients that they had nothing to worry about because a case was instituted earlier on, I believe that was in 1993, M779/93, I believe. Yes, that case was between the Eletu people and Lagos state government. And the Eletu had settled their claim in relation to the 254 hectares in question. So the doctrine of estoppel in law would obviously have stopped them from claiming anything more. In addition to the fact that the land had already been acquired and then subsequently given out to many people by Lagos state government C of O. So I knew something fishy was going on when they made these assertions. I looked at the judgment. We advised our clients to ignore them, but we reached out so that we could understand the basis of their claim. Long story cut short, the attempted enforcement, we ended up in court. The order for enforcement that they got was quashed. All this is in the book. Then the gremlins sprang up again and went back to the Supreme Court. And the Supreme Court, without any basis in law or common sense for that matter, in gross violation of each and every one of their own rule of practice, Supreme Court, without the benefit of survey in front of it, was busy multiplying and dividing land without surveying, something that was never pled in any part, whether in the lower court, court of appeal, was never raised and could never have been raised.
So I know that it got to a point that the matter got to the Supreme Court, and the Supreme Court said that the Eletu should get about 10 hectares, okay?
Yes.
And then, and just a minute, you know, and then there was an attempt to file a writ of possession that went beyond 10 hectares. Is that what happened?
Yes.
So I want our viewers to follow that sequence.
Let me share that with you. So there was a previous case that I have mentioned, M779/93. It was a case involving the Eletu and Lagos State. And in that case, a settlement was reached. Eletus were to accept 10 hectares of land in full and final settlement of their claim against Lagos State. The same Lagos State against whom they had settled were the ones who issued title to everybody because they had by then acquired each and every land in the Lekki Peninsula. They revoked all rights, customary and statutory, to every land in the entire axis, gazetted it, and subsequently, when they settled with the Eletu, that was filed as the judgment of the court. So the Eletus could no longer be asserting any claim. And that was what the Supreme Court said, that what you have been given in M779, the Supreme Court was careful. It was Akaaz, JSC, that delivered the lead judgment. And he said clearly that the fruit of their judgment given in M779/93, they should go and enjoy it. That is their own, which are the 10 hectares. So by the time they got to Lagos to file for enforcement, somebody fraudulently, I repeat it again, fraudulently underlined the consenting judgment of Rosevivor, JSC as it then was, where he said they had unextinguished equitable interest in 254 hectares, unextinguished equitable interest. Where that equitable interest is supposed to stand is left to him, but it was something said in consenting to the judgment of Akaaz, which gave only 10 hectares. They then underlined that portion of the judgment without the enrolled order of the Supreme Court They came to Lagos State and applied for a writ of possession, and they got it from the judge in Lagos State. The admin judge in the Lagos division gave them a writ of possession for 254 hectares.
Instead of 10?
Instead of 10, which was what the court gave. She proceeded.
After watching this very video I played, do you still have any doubt in your mind that Nigeria can never survive? My fellow Biafrans, it is either freedom or nothing. May Chukwu Okike Abiyama continue to guide and protect the Biafra Republic in exile, protect our Prime Minister Mazi Simon Ekpa, and protect our Supreme Mazi Nnamdi Kanu. Biafra government, peace, unity, progress, and equity. We move airborne.